Yes, Miss Fottrell.
My lords, my lady, good morning. As you know, I appear on behalf of the appellant with Miss Wilson, who was the junior in this case in the court below.
Yes.
My client is not present in court.
No, and nor is the child's father.
Indeed, not present, not represented. Miss Webber appears on behalf of the respondent local authority, and the guardian is neither present nor represented, but I believe you received a short note from her.
Yes. That
she aligns herself with the position of the local authority in the appeal.
Well, we are live streamed, as you know, and there will be the usual direction in relation to anonymity. So no report of this these proceedings is to identify the child or any members of the child's family, and we will do our best, particularly as it's essentially a point of principle.
Yes.
Not to give any identifying information. Particularly, I think experience tells that as soon as you start to read out a document, that all goes to pieces. So we'll be as careful as we can.
As will I. Thank you. I know that my lords and my lady have had an opportunity to read the documents in this case. May I begin by apologising for documents trickling through over the last 2 days. Funding for leading counsel was only provided last week, and Miss Wilson and I and our solicitor have done our best to comply with the directions that my lord made.
Well, to reassure you, I mean, when you say documents trickling through, that makes me feel anxious that they haven't all trickled through yet. But there's no complaint on our part. It's all been well prepared. Thank you very much indeed. You'll now tell us what we're meant to have in case.
Yes, indeed. There is a core appeal bundle.
Yes.
There is then an authorities bundle.
Yes.
And there is a supplementary bundle. Those are the three bundles which I hope you have.
Well, I think I speak for all of us saying that we've got, and insofar as we've needed to, we've read it.
Thank you very much. Well, as the court is aware, this is an appeal against a decision made by Her Honour Judge Earley, and the position of the mother in this appeal is quite unusual because she doesn't seek to set aside the substantive findings that were made by the court, nor does she contest in any way the final order that was made by the court, and this court will be aware that that was her position at the conclusion of the proceedings in the court below. So the appeal today is on a very narrow but an important point in relation not just to this case but also potentially in relation to other cases. And I will confine myself in my submissions, as Miss Wilson did in her very thorough skeleton, to the judgment itself, the authorities in relation to the use of criminal definitions particularly, but also wider definitions in family proceedings, and take my lords and my lady to the NSPCC guidance and the working together documents.
Is Ground 2 something we need to take time on?
Very little time when we get there. What I propose doing, if I may, is to go through Ground 1. That seems to me to be the focus of this appeal. There are 1 or 2 points I would make on Ground 2, but I didn't intend elaborating in any length.
Well, could we start at the end and just think about what it is that you're actually asking us to do, because we're all aware that on the ground, as it were, the appeal is not going to affect actual events. It would be of interest, so we'd have the whole picture, to know, I think that a child was expected.
A child has been born. The appellant gave birth to a child on the 31st of December. That child is the subject of proceedings, has been removed from the appellant's care and placed in foster care, and those proceedings, Section 31 proceedings, are active before Her Honour Judge Earley.
Thank you. Could we next then, before you embark upon the substantive submissions, just go to the end of Miss Wilson's skeleton argument? Yes. At page, I have it at page 26.
Yes.
It's 27 in 26 is correct. Paragraph 50, where the remedy is set out.
Yes.
So could we look in real terms at what it is that you would be asking for with regard to the judgment, and in a sense what form of editing is it that you want?
Well, my lord, as you can see from Miss Wilson's document, paragraph 50, subparagraph 1, the primary focus is paragraph 53
Yes.
of the judgment, which you will find at 47 of your bundle. And it's really the first sentence of that
So what, I mean,
that
what,
we would
what,
say
what,
needs
what
to
should
be
happen?
excised by this
Right.
court.
So you want first sentence blue penciled,
Yes.
and
It would also, in my submission, be necessary to blue pencil, if I can take my lord's expression, the references to the NSPCC definition of child abuse, if, of course, the court took the view that it was either unnecessary or unhelpful to define the findings in that framework.
so really what you're asking for is to strike out paragraph 53 and replace it with some more generalised statement that this all of this crosses the threshold.
Well, yes, and my lord, that in my submission is a relatively straightforward exercise if one looks at the judge's own findings in the judgment, particularly at paragraph 42, her conclusion that both parents created an environment where the child may have been exposed to inappropriate material and sexual abuse, and then at paragraph 45, her finding that both parents exposed the child and so on. If those, and I will, if I may, take the court through the judgment in a moment, but if the court looks at those two findings, our ultimate submission is that those findings stand alone, and the difficulty with the judges placing those findings within the framework of the NSPCC guidance is that it added confusion, or it adds a gloss, or it adds a definition which is not either necessary or helpful. But that's a two-sentence summary of all of the submissions I intend making.
Just before we leave this and I let you get ahead, when we come to the findings themselves at paragraph 61,
yes, paragraph 61.
What is the sort of exercise that you're advocating there?
It would be 61 Roman numeral 3, but again, that would need to be excised. My lords, my
Just
lady,
the words
this could-
constitutes sexual abuse and, that's all
Yes,
you need. That
yes,
you'd ask for.
I was about to get there.
Yeah.
Exposure to this caused the child significant emotional harm.
That stays.
Yes, that we don't dispute.
Right, so you just trying to see
Yes,
what the contours of this are. Are you effectively seeking to move this to emotional abuse?
no,
I mean, which would it would, if one simply said exposure to this material caused child significant emotional harm, that's what would be left on that
well,
approach.
it's not always particularly helpful for judges to reduce the narrative judgment to a list of findings. That shouldn't be read on its own. It needs to be read in the context of paragraphs 42 and 45 in my submission. And if one looks at the paragraph 45, you can see in particular the finding that both parents exposed the child to sexually inappropriate material. This led to confusion for her young and impressionable mind as to what was appropriate for herself. And then at paragraph 49, it goes on to say they failed to protect her, mother in particular, failed to protect her from seeing explicit material in the home. And of course, the consequence of that was that she herself behaved in a sexually inappropriate way, in a sexualized way. So I hope it's clear from our document, and I will make it clear in submissions if I may. The mother's stance in this appeal is not to in any way seek to minimise the findings. They are very serious findings.
We don't take it as that at all.
Yes.
It's simply that you're going at some stage to have to deal with the fact that the judge decided, and I don't think she could be criticised for this, to conclude by saying that these are my findings in respect of threshold.
Yes.
And the threshold can only be crossed in relation to significant harm.
Yes.
And harm is defined, as you know, in various ways.
Yes, of course.
To do with physical, sexual, emotional harm. And so we'll need to understand what you're saying a judge or this judge should have done when completing her task with regard to the Section 31 criteria.
Yes, I understand. Yes.
Okay, that's been very helpful to me at least. Thank you.
Thank you. May I then just go back to make a few preliminary points? And I know the court already has these, so I won't labour them. As you understand, the mother's position in this appeal, and I'll just reiterate this, is she's not seeking in any way to minimise the seriousness of the findings that were made against her, nor does she seek in any way to excuse the negligent behaviour on her part, which led to her daughter behaving in a sexualised way. You will have gleaned from the judgment, the mother was the parent who blew the whistle, as it were, and involved the police and social services with her child. And you will also have gleaned from the careful judgment of Her Honour Judge Earley that the mother is somebody who has a significant range of difficulties and challenges in her own circumstances and vulnerabilities. And I make those points because, of course, this court will have in mind, as indeed Judge Earley no doubt had in mind, that the findings that were made by her in this case are not just confined to this case. This is a young mother who is already involved in a second set of proceedings in relation to a new child. And so when one thinks, as one must, and this court, in my submission, needs to give consideration to this in due course, when one thinks about the purpose of a fact-finding judgment in family proceedings, it isn't, of course, just confined to the particular set of proceedings, particularly with a young parent. It has consequences for future proceedings. It has consequences for other children. And that is particularly stark in this case because by the time of the conclusion of the trial in this case, before Her Honour Judge Earley, there was agreement as to outcome. And so this wasn't a case where there was a split hearing and assessments were to be undertaken at that point. It was a composite hearing, as my lords and my lady are aware. But going forward, this judgment and the conclusions of this judge in relation to this mother do form a platform for future assessment. And therefore it is vital that there is clarity about the meaning and implications of the findings. And it is vital that the consequences of those findings can be understood by those who have to carry out the assessments. Those are points I know that are familiar to the court, but they are important points in terms of looking at this particular appeal. May I then ask the court to look at the judgment itself, and I will, if I may, just signpost a number of points in the judgment. Before getting there, of course, I would remind the court that all of this has been addressed by Miss Wilson in her skeleton, and I will track some of the skeleton, but I won't repeat it in full. But if we could turn to look at the judgment, and I'd reiterate the point that there's no issue being taken on behalf of the mother as to the way in which this trial was conducted or the very thorough judgment that the judge produced. We accept and acknowledge and recognise that. But if one looks at the actual findings made by the judge, she begins the real meat of the judgment, if you like, at paragraph 39, where she asks herself the question, how did this child create the images which were on her phone? And this is at page 43 of the core bundle. And you can see at the top of the paragraph 39, that there is joint acceptance from the parties, including the appellant, of course, that the child's behaviour in creating the images properly could be described as sexualised behaviour. So that's not something that the appellant was seeking to resile from. And there is the linking at the bottom of the paragraph to the Hackett continuum and where those particular images would fall on the Hackett continuum. Then at paragraph 42...
As a matter of interest, I speaking myself, hadn't come across this concept before and have looked to see a little bit more of what it is. In better fairness, my lord has done that work and informed us. But have you come across the Hackett continuum concept before?
I've come across it in cases of this nature, but if you're about to ask me anything about where it comes from or what it means, I'm not sure.
I will keep any supplemental questions for Ms. Wilson. But No, it's just of interest, not having come across it before.
It is something which is quite frequently referred to, I think, by experts and
that's an NSPCC product, or at least they've publicised it widely.
Yes, I believe it was published in 2010, 2011.
And so, are we to? I mean, just if we do have to spend time, and you may have gleaned that I'm not that enthusiastic about ground two, but if we have to spend time on that, then do we take it that at least there was some NSPCC material before the judge? Because
that's my understanding.
That didn't just come in at the clarification stage.
Not as far as I'm aware, no.
All right.
The Hackett continuum is, I don't want to give evidence, but it's something frequently referred to by professionals in, and by that I mean police, social workers, guardians,
right.
To, as it were, locate the behaviour, impact, consequences on a spectrum, as it were.
Right, so this amber is code for problematic.
Problematic, but it's also context specific. It's age related, related to the age of the particular child, whether the behaviour is occurring in a particular context, and the Hackett continuum and the guidance that goes with it. It's academic as far as I understand it, and it assists in terms of understanding what is acceptable, normal, sexualised behaviour in particular contexts and what is problematic, and this of course tips into problematic because of the context and the nature of it and the age of the child. My lady, just returning then to the judgment, if I could then draw your attention to what the local authority was seeking at paragraph 41. And that sets out the local authority was seeking a finding that the creation of the images is evidence of the child having been sexually abused, and assert that the perpetrator of this abuse is likely to have been the father.
But that was a different sort of allegation of sexual abuse.
Indeed. And the local authority's findings are particularised in great detail. I don't think I need to go into that for the purposes of...
No, but I mean, insofar as we're looking at labels here, that the form of sexual abuse there was malign sexual abuse by the father, in particular in relation to marks and so forth.
It was contact-based sexual abuse. Of course, in due course, when we look at the working together definition and we look at the guidance from the NSPCC, that would fit squarely within both that type of contact abuse, but that wasn't the substance of the judge's finding. But in my submission, there is obviously some importance and relevance, as I said a moment ago, to paragraph 42, because there the judge recognises that there is evidence that both parents created an environment where the child may have been exposed to sexually inappropriate material / sexual abuse. And then she goes on in the next paragraphs to deal with the father, and she returns to the mother at paragraph 45.
44?
Forgive me, yes, paragraph 44. And this is in relation to the material which was in the mother's own possession and in her household, which the judge found wasn't properly kept from the child, to which the child was exposed. And then the finding at paragraph 45 is really the core finding in relation to this. A finding that both parents have exposed the child to sexually inappropriate material, and this led to confusion in her young and impressionable mind as to what was appropriate for herself. And then if you stand back and pause for a moment and look at that finding, in my submission there are obviously a number of points in there which are important. First of all, the judge is making a positive finding that both of the parents exposed her to sexually inappropriate material, but also that that was the cause of the sexualized behaviour, and of course that is the cause of the harm to the child. And then further down in the judgment, I would invite this court to look at paragraph 49. This relates again to the appellant. This is a further and slightly different finding, which is a finding that the appellant also failed to protect the child from seeing sexually explicit material in her home. And
why is that slightly different?
well, I suppose it's more of a specific failure to protect finding. It seemed to us, that's a point that Miss Wilson makes in her document. I see it follows from the finding above, but it's a specific finding in relation to how the material was kept in the mother's home, and in particular whether there was material on the phone of the mother's partner, and whether the mother herself was responsible and had agency, as it were, over that, or whether it was the mother's partner who had responsibility and agency. And it seemed to us that that was a failure to protect finding. But of course, one has to read it all together. I'm not suggesting for a moment it's anything other than a continuation of the judge's analysis in relation to that issue. Now, pausing there for a moment, it will be my submission to the court in due course that those findings are obviously very serious findings. They are highly consequential in terms of the child, but also highly consequential in terms of the mother. Because as my Lord Justice Jackson observed in the granting of permission in this case, those findings amount to findings of negligence on the part of a parent. And that is not just about intention or lack of intention. It is exposing a child to significant harm within the context of Section 31, owing to a failure to be vigilant, owing to negligence on the part of the parent within the household. It will be in due course our submission that those findings are sufficient. They stand alone. And for any assessor looking at this in the future, in the near future as it happens, those are serious findings to grapple with, and they raise a risk profile that needs to be evaluated and assessed, and raise serious questions about how those matters are to be managed going forward.
So the submission of principle that you make is that the judge could and should have stopped there.
Yes.
In terms of her task.
Yes. Those are the core findings, if I can put it that way.
Yes, but you know what I'm going to ask you, which is this.
I think I do, but I don't want to assume.
That the actual task that the judge was carrying out here was making findings in order to determine whether, and if so, how the threshold
yes.
for intervention was crossed. And so, although, and it's quite okay because we know what it contains, although the Children Act is not included in the authorities, aren't you going to have to grapple at some stage with the exercise that the judge grappled with, whether correctly or incorrectly, which is how the threshold was crossed and in what respect?
Well, my Lord, I see the point, but I think if one reads those paragraphs together, and I'll come to the paragraph 53 in a moment because I want to deal with that, if I may, and then deal with
yes.
paragraph 61. But if one reads those points together, those points of the judge's own judgment, paragraph 42, 45 and 49, at paragraph 42, there is a clear finding that the child
yes.
has been exposed to inappropriate material.
Yes.
And of course, that exposure to inappropriate material is a cause of emotional harm, significant emotional harm. I mean, that is well understood, I think, and well established. And certainly my understanding, reading that judgment, is that is the finding that the judge is making there, and then going on to look at the consequences of that it triggered for the child.
So is it it's not, we've touched on this before, but we'd be explicit about this to understand whether it is your submission that if one looks back to paragraph 45,
42, I think one has to start
42 and 45, that what the judge found and should have been finding was that this exposure to sexual material caused the child significant emotional harm.
Yes.
So it's very helpful to be exact about what we have to agree or disagree with. But in effect, your thesis would be that, I mean, whichever way one looks at it, this is bad. You're not challenging that. But in terms of being analytical about it, although the content of the material that a child should not be exposed to happen to be sexual,
Yes.
the threshold finding ought to have been emotional harm or emotional abuse, and not sexual harm or sexual abuse. Is that what it comes to?
Well,
Or,
my lord,
do you,
there's
as it were, shrink from that?
That is the primary submission that we would make. There is a slightly difficult element of this case because some of the child's sexualized behavior involved physical acts by the child, and there was a question mark about the link between those and some manifestation of discomfort in the genital area for the child, and the judge dealt with that in her judgment. What she doesn't in the judgment do is suggest that there was significant physical harm, as it were, as a consequence of that behaviour. But I recognise that that is a factor in this case because the nature of the child's, or the extent of her sexualised behaviour, was it was extensive, or it was considerable for a child of this age, and the acts that this child engaged in were varied. Does that answer my lord's question?
Keep going. I think my lord has a question.
I just was going to ask this. You've asked us to focus on 42, 45, 49. I just wondered whether 52 was part and parcel of that sequence, because in 52, the final sentence is a judge's finding on the balance of probabilities that the child was given a phone. And in context, that must be either by the mother or KS to either keep her quiet or distract her from what was happening. That, I think, is in relation to domestic abuse. Mm-hmm. And she was inappropriately able to access and so, in a sense, one has to, I think, look at that in the context of your submission about failure to protect, mm-hmm. because actually here you've got something that's quite active. The child is being given a phone on which the mother knows that this material is stored.
Yes. I hope I wasn't unclear on my submission about failure to protect. The paragraph 49 seemed to us to be an additional submission or an additional finding by the judge, mm-hmm. in addition to her findings of 42 and 45.
Right.
So obviously if one is going to read this judgment, one has to read it as a whole. Mm-hmm. And the judge goes on, as my lord has said, at paragraph 52. And then, of course, she goes on at paragraph 53 to make I suppose, what one might call a concluding finding, bringing all of these strands together. And that seemed to us to be the way in which the judge was approaching the fact-finding exercise, that she sets out from paragraphs 42 through to paragraph 53 the findings that she makes in relation to the mother in particular, and one looks at those 45, 42 as a general finding in relation to both, 45 in relation to the child and the conclusions as to exposure, 49, and as my lord says, 52 and then 53. It is 53 that is the problematic paragraph, we would say, and of course that is the focus of this appeal. And it's problematic in two senses, one as to substance and the other as to procedure, but I hear what my Lord Jackson has said, and I'll come back to that in relation to ground two. But may I then turn to the substance of paragraph 53? And if one looks at the substance of paragraph 53, it is our submission that the first sentence of that is very problematic, and it is that where the judge went wrong. And we say that because of the context in which she makes it, and that is if one looks at the first sentence, that is clearly drawn from the NSPCC definition, or that's what the judge tells us in the judgment. The NSPCC definition of child sexual abuse, and she goes on to set it out. In my judgment, this is consistent with the working together to safeguard children definition of non-contact sexual abuse, as including, and she quotes. Now, we need, in my submission, to look at that, each element of it. And perhaps the only part of it we say that stands is I do not find that either parent either intended such, I do not find that either parent intended such abuse to take place. However, they neglected their daughter by failing to ensure that she was safeguarded from
So the
their
full sentences
adult.
and that the second sentence survives.
Yes, that must follow from those paragraphs of the judgment that we've looked at. Could I take the court then through both the NSPCC guidance and the working together guidance? And this may be the appropriate time to do that. First of all, if I could take you to the working together guidance, and you will find that in the appeal bundle at page 61, but you'll also find it in the supplementary bundle at page 3. It begins in the supplementary bundle. And before looking at what is in the appeal bundle, may I just make a few general points about the guidance itself. This I know will be familiar to some members of the court, but of course the working together guidance is statutory guidance. And the most recent iteration of this, although this wasn't the iteration before Her Honour Judge Earley, but there was no change to the substance of the definitions. Most recent iteration is the December 2023 iteration.
So I think the one that did apply was July 2018.
2018, indeed. And that, of course, featured in the judgment of Mr. Justice MacDonald, which I'll come to in due course. But just a few points, if I may, about the guidance. If one turns to page 10 of the supplementary bundle, you see there information as to what the guidance is intended to cover. At halfway down the paragraph, this guidance covers the legislative framework that applies to individuals, organisations and agencies.
What paragraph are you reading?
I'm reading under the heading about this guidance, paragraph 1, bullet point 1, at page 10 of the supplementary.
Yes, I've now got it. Thank
Yes.
you.
It's 8, page 8.
Hmm.
Yes, yes.
I'm sorry, it's 8 on the hard copy.
Thank you.
But obviously that is crucial because it applies to the legislative framework, which means, of course, that it must be read in tandem with the Children Act itself.
This guidance must be followed by agencies unless there's a compelling reason.
Of course, it's
not to do
section
so.
7 of the
That's
1970s.
statutory guidance, but it doesn't obviously govern the court.
No, but it is.
It's an important source of information.
It is an important source of information, but it also is statutory guidance for those professionals working with children in the context of proceedings under Section 31.
That's
and
right.
of course,
the judgment of the court has not just got to be understood by the professionals, it's got to be understood by the individuals in the case and anybody into whose hands it might fall.
yes, and particularly those professionals who are assessing risk and looking at risk profile. That is a fundamental part of the fact-finding process and a fundamental purpose of a fact-finding judgment. My lords and my lady have the point in relation to this. If one then goes down, it's my page 12 in the supplementary bundle, it's internal page 10 to paragraph 8, and this is my lord's point a moment ago. The statutory guidance sets out roles for organisations, agencies and so on to deliver support, safeguarding and protection. There are a few general points I would make about the guidance. The guidance, of course, is settled after a wide consultation process, and this consultation process for the 2023 guidance began, I believe, in June of last year and finished in September of last year, over 100 organisations and agencies contribute to the process. That includes the Association of Directors of Children's Services, it includes organisations like the ALC, it includes specific local authorities, it includes CAFCA. So it's a wide-ranging exercise, and in my submission that is important to bear in mind when one considers, as this court must, which guidance should be relied on and what is the authority, if you like, or the value of particular guidance, and how one can see a process to which a range of actors are contributing within the process. So that is the way in which the 2023 guidance is settled. It is obviously relevant that the definitions, in particular in relation to sexual abuse, were not part of the most recent consultation exercise. There was no suggestion that they should be changed. And we see that when we come to look at the REP decision, because when Mr. Justice MacDonald was looking at the REP case and settling out definitions from the Working Together guidance, of course, he drew on the 2018 guidance, and it's the same as that in the 2020 guidance. If one then goes to the appeal bundle and looks at the substance of the guidance in relation to sexual abuse, and this is at page 62, and there are just a few points that I'd like to signpost, if I may, here. And these were, of course, picked up by my Lord Justice Jackson in the permission decision of this court. The first sentence of that definition is of some importance. And the first sentence provides that sexual abuse involves forcing or enticing a child or a young person to take part in sexual activities, not necessarily involving a high degree of violence, whether or not the child is aware of what's happening. Now, we would place some emphasis, we say the court would need to place some emphasis on that first part of the sentence, that it involves forcing or enticing a child. And it obviously goes on in the definition to specify contact-related abuse and non-contact related activities. And of course, these are illustrative examples which are intended to assist. We see that there is an anchor here, or a hook here, in relation to this particular case, which is involving a child in looking at or watching sexual activities. And you can see it goes on in the sentence after that to say sexual abuse can take place online and so on. Now, if one, in this case, was to apply that definition, in my submission, the judge would not have arrived at the conclusion that she arrived at in paragraph 53. But can I pause that for a moment and look at the NSPCC definition?
So I want to get the submission done. That taking the formula involving a child in looking at sexual activity
involves forcing or enticing.
Well, just going to the middle of the phrase at the moment, which is that non-contact activities would include involving a child in looking at sexual activity. You see the words
yes, of course,
I'm picking out of that. Your submission is that is a subset of forcing or enticing.
Well, that seems to us to be how one has to read that definition.
Right. So when you say that had the judge applied that, then she could not have concluded that this was sexual abuse within that definition.
That's our submission.
That's the submission.
Yes.
I know it's not a statute, obviously,
Yes.
and you must. I will rein myself back. But that is quite a difficult submission when you look at some of the other phrases in this definition. Because how could you force or entice a child to encourage a child to behave in sexually inappropriate ways? So if you read on, it talks about encouraging children. You could probably make the same point about grooming a child in preparation for the case. Those subparagraphs are very difficult to understand if you have to go through the entryway or the filter of it. It only arises if you forced or enticed a child in the first place.
Sorry, just where is my lady looking? I'm sorry. Is
Well,
it the
if you start
second
onto the
sentence that
definition of
begins?
sexual abuse, so
Yes.
as I've understood it, your submission is it all starts with forcing or enticing a child. That gets read into the whole definition. Yeah?
Well, that's our understanding of the definition.
Then you go to non-contact activities, and my lord's asked you about involving children at looking at sexual images or watching sexual activities. And we just paused there, and I understood your submission to be that has to be understood through the lens of forcing or enticing.
Yep. To read them together, yes, that's my submission.
Carry on a bit. The next bit is encouraging children to behave in sexually inappropriate ways. And my question to you is, applying the same logic, how could you force or entice a child, force or entice to encourage a child to behave in a sexually inappropriate way? Do you see what I mean? That doesn't sort of work.
I do understand my lady's submission, but those two things don't seem to me to sit uncomfortably together, if I may say so, because forcing or enticing is quite a broad phrase, as it were, and if one is looking at encouraging a child to behave in sexually inappropriate ways, that there are multiple examples of those sorts of behaviours in family cases in which findings are made. Encouraging, enticing, forcing, those matters are, in my submission, consistent.
As sexual abuse. They'd be looked at as sexual abuse.
Indeed. Well, if one reads this definition as a whole, I mean, I don't understand that the definition is suggesting that the first sentence stands alone, and then the other two sentences, contact is the following examples, non-contact are the following examples. It surely has to be read as a whole. And that means that one has to, if one is looking at sexual abuse, and this is the definition of sexual abuse, or guidance as to how one defines sexual abuse, then one has to read it in its entirety. One can't just jump in and say, well, this particular thing, this example of non-contact abuse, is sexual abuse. One has to look at whether it has those other elements to it, that there is an element of forcing or enticing. That seems to us to be how it has to be read. And if that's not right, how it has to be read, then we're very much in the territory that in a moment I will suggest this court should not, or family courts should not be in, where there is ambiguity as to meaning, and where putting a finding in the framework of a definition introduces confusion rather than clarity. And that is what we are told in RIOR, and we're told in HN, and we're told in other authorities, is very problematic for the family court. So if one starts to put a gloss on a finding, or if one tries to locate a finding within a framework, that being a framework that seeks to define it, then one has perhaps the sort of possibilities of different interpretations that my lady and I are having. My lady will obviously decide which one is right, but our suggestion is that if you start to do that and take a finding a step further, it has to be because that assists, because it provides clarity. If it doesn't provide clarity,
okay, no, we're straying out. I think I've got the general drift. I just wanted to. I have your submission marked as there has to be an element of force or enticement, really, as part of how you understand sexual abuse. Is that a reasonable summary?
If this definition is going to be applied, then you have to read it in its entirety, if I may put it that way, rather than suggesting, because it's not our submission to this court that this court needs to settle on a definition of sexual abuse. In fact, it's very much the opposite, that settling on a definition of sexual abuse is going to be hugely problematic in the context of family courts making findings in Section 31 or Section 8 proceedings. So we say that the definitions should be used only insofar as they shed light, rather than causing confusion. I hope that answers my lady's question.
Thank you very much.
May I then move on to look at the NSPCC definition? Thank you. And that is in the core bundle, the appeal bundle, at page 60. And you can see there, this was updated as the judge, Her Honour Judge Earley says, on the 16th of May 2023, so very recently before the judgment. And again, our submission is that one has to read that definition, if it is a definition or guidance, in its entirety. So the first paragraph.
Sorry, I lost the page, where are you?
It is page 60 of the appeal bundle.
Thanks.
So the first paragraph begins, CSA is when a child is forced or persuaded, those being crucial, to take part in sexual activities, and then goes on to say it may involve physical contact or non-contact, and it can happen online or offline. And then it goes on further down the page to set out contact and non-contact abuse. Now, pausing there before I look at the specifics of the non-contact abuse, again, it seems to us that one has to read the first paragraph together with the subsequent paragraphs. In other words, the gateway, if you like, into the definition, or the gateway into the guidance, is the first sentence of the first paragraph. That child sexual abuse is when a child is forced or persuaded. And then one goes down to look at non-contact abuse, and the judge's finding in this case being allowing, forgive me, making, not taking proper measures. The second bullet point, not taking proper measures.
Isn't there you described the gateway as forced or persuaded to take part in.
Well,
I'm
yes.
not sure. I'm not sure that the third bullet point could, on any view, get through the gateway.
Well, the difficulty here again is the same difficulty we looked at a moment ago with the working together document. That the guidance, we say, this entire page needs to be read in its entirety, because at the top of the page, one is being given a definition of child sexual abuse, and then it is being particularised by a number of examples. It isn't particularly clear, if I may say. It does introduce confusion, and there is a degree.
It's not consistent, is it? I mean, essentially, if it said forced, persuaded, or allowed, then the third bullet point would fall naturally within that. But on any ordinary use of language, you're not forcing or persuading a child to take part in sexual activity. If you're grossly negligent about allowing them, it just doesn't fit together in the way that you suggest.
Well, no, there's 2 points I would make about it. First of all, it's guidance from the NSPCC. The NSPCC is obviously a charity. It's got a particular position within the statute, which we recognise. My Lord makes that point in the document. But how this document is drafted and what its purpose is really a question that this court has to consider in the context of this appeal. And if, for example, one is going to say paragraph 1 is a general global paragraph which isn't in any way linked to what is subsequently set out in the 2 paragraphs of examples, that's a slightly difficult and somewhat ambiguous and problematic assumption to make, because it appears from the document itself that the document is intending to provide guidance as to what child sexual abuse actually is. And one has to look at the paragraph that defines it and then the subsequent examples. I take my Lord's point that it doesn't appear to be consistent. But if that's right, then what is one to make of the opening paragraph? What does it mean
All
to
the
say...
other bullet points do go through your gateway, but not this one.
But what is one to make of that? And I suppose in my Lord's, if I can come back to my Lord's observations in granting permission in this case, one of the observations that my Lord made was that there's a possibility that the guidance, either a set of guidance, either the statutory guidance or the NSPCC guidance, may introduce ambiguity. And in my submission, The real difficulty here is if one fast forward to a social worker undertaking an assessment within the currency of these proceedings in relation to the appellant's recently born child, and that is the definition that the social worker turns to. The questions that my lord and I are discussing are questions which will arise for a social worker. If this is the definition under which I am operating, to what extent am I to conclude that there was active agency, persuasion, enticing, forcing, whatever the phrase is, and does that follow from the characterisation of sexual abuse? And that, I suppose, takes us around the houses to the question of whether it is appropriate or helpful for a judge to take that additional step once a finding has been made to locate it within either of these two frameworks. But if it is going to be located within either framework, we would say it has to be the statutory guidance rather than the NSPCC guidance.
So is your submission basically that, not being unduly critical, because as my lady says, these are not statutes, that if one was looking for a definition or a glossary of sexual abuse, both of these documents in their different ways have some element of problem for the particular circumstances that we are concerned with. We've looked at the possibility of ambiguity in the first one, and we've got your gateway point in the second one. And so does that represent your submission about these documents? I mean, you're not encouraging the law to lay down a definition of sexual abuse, even if that was entirely possible. But when one looks at such definitions as are attempted here, your survey suggests that there's some problem with each of them.
It may return to the point my lord raised with me a moment ago in relation to the working together as to who is the target audience, if you like, for the guidance, and if those documents were intended to assist social workers, then that is one issue. But whether this court or a family court should import those as definitions which are to be followed by judges is really the question. So when a judge is asked to look at the issue of whether there has been sexual abuse in a particular context, in this context, Section 31, does that assist the fact-finding exercise? It seems to us that where there are potential conflicting interpretations, it isn't helpful to adopt a definition. And there are potential conflicting interpretations. And I don't think it's just a potato-potato exercise. If, for example, it appears that the defining paragraph or the opening paragraph of the NSPCC guidance has some link to what follows. And if not, then how is one to read what follows? And indeed, how is one to read the paragraph? Is it standalone? And it can't be a standalone because the guidance has to be read as a whole. So our submission to this court would be, of course, the working together document is a document that judges do look at. And I'll take the court in a moment to the decision of Mr. Justice MacDonald, because that was offered to this judge by way of legal guidance and assistance. But we don't suggest that this court should settle on a definition. And we certainly don't suggest that this court should settle on the definition set out in the NSPCC guidance. Does that answer my lord's question?
Thank you.
May I then just make a few points about, first of all, looking at the decision of Mr. Justice MacDonald in Re-P, and it's just a passing reference to that, and then deal with the issue of Re-Or and the subsequent cases about where and how appropriate it is for a judge just to go beyond the fact-finding and place things in a guidance framework. The Re-P case of Mr. Justice MacDonald is in the authorities bundle, and it is at page 3 of the authorities bundle.
So this is the filleted
This is
version of the
version
enormous
of
judgment.
the extremely long judgment. And just to place this in context, my lords may be familiar with it, my lady may not. It is a judgment at the conclusion of an intergenerational sexual abuse case, which Mr. Justice MacDonald heard over many months. We've included this for two reasons. Firstly, because of the very comprehensive consideration by Mr. Justice MacDonald of sexual abuse and how it is to be approached by the family court, but also it was the judgment which was provided to Her Honour Judge Earley in the court below. She was signposted to certain parts of it, including paragraph 4, which you will find at page 6. And paragraph 4, Mr. Justice MacDonald does refer to the definition from the glossary from the 2018 guidance, setting out the global definition. I don't say to this court it's helpful really beyond that, because that is familiar territory to family judges. And of course that was a qualitatively different exercise that Mr. Justice MacDonald was undertaking. May I then take the court on to REAR, which is the second authority in the authorities bundle. And I will, if I may, just go through a number of paragraphs of this judgment, which again I think is familiar territory to family judges. But of course the key point that come out of the REAR decision is the importance of the family court not importing into its own reasoning criminal definitions. But the REAR decision is also developed by the President in subsequent decisions, including A, B and C, as to importing other types of material in to assist. So could I ask you to look particularly at paragraph 61 and 62, which is at page 62 of the authorities bundle. And it's really paragraph 62, in which the President sets out what is well known and understood in the second sentence: the focus and purpose of a fact-finding hearing, investigation in the context of a case concerning the future welfare of children, is obviously different to that exercise undertaken in the criminal court. And then about halfway down the paragraph at line E, just under line E, the President says this: in family proceedings, the outcome of a fact-finding hearing will normally be a narrative account of what the court has determined in the lives of a number of people, often over a significant period of time. And he goes on to make the point that we have discussed today. The primary purpose is to determine, as best that may be done, what has gone on in the past, so that that knowledge may inform the ultimate welfare evaluation, where the court will choose which option is best for the child, with the court's eyes open to such risks as the factual determination may have established. And then, of course, there is the further observations. Forgive me. Just had a computer malfunction, if you'll just bear with me. At paragraph 65, the second sentence there, having gone through the judgments of Lady Butler-Sloss and a judgment of Mr. Justice Headley as to the use of criminal concepts in family proceedings. The second sentence in paragraph 65 begins: against that background, it must be clear that criminal law concepts, such as the elements needed to establish guilt of a particular crime or defence, have neither relevance nor function within the process of fact-finding in the family court. And he goes on in the last sentence to say, how is such a finding to be understood both by professionals and the individual family members in the case itself? The potential for such a finding to be misunderstood and to cause profound upset and harm is to me all too clear. Paragraph 66, we would say, is also relevant, and this, of course, has echoes in the judgment of my Lord Mr. Justice Cobb in the F&M case, where he says, looked at from another angle, if the family court were required to deploy criminal law directly into its analysis, of the evidence at a fact-finding hearing such as this, the potential for the process to become unnecessarily bogged down in legal technicality is also plain to see. Now, that phrase and that observation by the President is one that we say is highly relevant here, that if one introduces a concept or a definition which seeks to frame or explain findings of fact, there is every possibility of the court or those readers of the judgment who have to undertake welfare assessments becoming bogged down in legal technicality, but also misinterpretation. And then paragraph 67, the second sentence of paragraph 67 records the observations of Lord Justice Higginbottom. What matters in a fact-finding hearing are findings of fact. And we say that is something which, an observation which applies to this exercise of course, undertaken by Her Honour Judge Earley with such care. May I then turn to the ABC decision?
Before we go there,
Yes, forgive me.
it was paragraph 86. I mean, it's all vanilla law. It's not intended to be breaking ground, but I quite understand as it were, the snappy way that Lord Justice Higginbottom put it. But actually, there's more to a fact-finding hearing. It's not just there to find facts, and that is what it's doing. But it's also there in order to establish typically whether the threshold is crossed. I mean, if one again reverses a little bit, give me a moment. I think we come upon an old case of my Lord's, paragraph 63, which where the President took out some passages from Re-U back in 2005.
Yes.
And you can see one of those is paragraph 26 at letter C on page 63. It is for the purpose of satisfying that threshold that the local authority seeks to prove specific facts. And again, this is very basic.
Mm-hmm.
And so I'm, as you'll gather, not easy in my mind about your suggestion that the judge could just simply find facts and then embark upon welfare.
I hope that's not my submission.
No,
I think
but,
that's a
I mean,
little
there
reductive.
has to
If that's
be-
how I'm coming across, then
right.
that certainly wasn't my intention.
Well, I want at some stage for us to look at section 31 in order to see how that fits in with these submissions. But anyhow,
Well,
you were going on from RIAR.
Yes, I was indeed. Forgive me. So if I could ask you then to look at the A, B and C case.
Thank you.
Forgive me, the A, B and C case, which is the 2023 decision of President, my Lord Justice Jackson and Lady Justice McCarr. And that begins at page 78 of the authorities bundle. And if I could ask you particularly to look at paragraph 20. And this again is the President revisiting the ratio in the Rior decision, but also considering and expanding on this question of introduction of definitions and concepts which may cause the court to become bogged down or distracted. And so he says there, see, judges have been keen, and refers to a judgment of my Lord Mr. Justice Cobb. Judges have been keen to prevent the family court becoming bogged down or distracted. The true issues to be obfuscated by the legal technicality that would be introduced by definitions which were to be implied as a matter of law. And then he goes on to say, in my submission, this is of some assistance to this court today. He goes on to say that whilst the focus of those decisions was upon the proposition that the definitions in question were applicable under the criminal law, the mischief, which it has been held should be avoided, applies in equal measure to any alternative definitions that may be promulgated. And that, in my submission, raises an important question for this court as to the extent to which the introduction of these definitions, and in particular the NSPCC definition, may have the consequence of causing courts in the future to become bogged down in this legal technicality, this obfuscation, and this confusion. Because, of course, as my Lord Justice Jackson has pointed out, the exercise is to find facts in order to decide whether the threshold has been crossed. Because if one is unable to demonstrate that the threshold has been crossed on the basis of the facts found, then one doesn't get, as it were, to the welfare evaluation in any event. But the welfare evaluation is informed by the narrative findings that the court makes in relation to its judgment. That point is reiterated again in the H&N case. I don't particularly need to take the court to it because it's something of an echo chamber around the Rior decision, and Miss Wilson has helpfully, in my submission, extracted that into the skeleton argument. But we say that those judgments are important because they clearly signpost the mischief, as the President put it, in the A, B and C case that arises when definitions are introduced to put a framework, as it were, around findings of fact. And we would say that when one then stands back and looks at the exercise that Her Honour Judge Earley undertook, she did properly and fully make findings of fact in this case. But where we say she fell into error was where she sought to locate those within the framework of either a statutory definition or the NSPCC definition. And of course, if the court was with us on the points that we make about the statutory definition, then her findings of fact within the working together framework would not have led her to conclude that this was sexual abuse. It would have led her to conclude, as she did, that this child had suffered significant emotional harm as a consequence of negligent parenting.
Just reminding myself of what was in issue in A, B and C, it was, we see at paragraph 13 of that decision that the appellants were seeking to challenge the failure of the trial judge to provide clear definitions of rape, sexual assault and consent.
Yes.
And also some broader
rape myths, I think, was also an issue.
Concerns about rape myths. So that was the focus in that particular case of the President's observations about the mischief of definitions.
Yes.
And paragraph 21, difficult to understand why, on behalf of victims, new thresholds should be introduced for a complainant to satisfy before the court could find that the person had indeed been a victim of behaviour of that sort.
Yes.
Now, I think the point you're going to have to deal with at some stage is the fact that the court, in our case, is acting within a statutory framework which does include definitions. So you'll come to it when when you
Well,
think best.
I'm happy to come to it now. I didn't intend taking you to too much more by way of authorities.
Well, would you like to finish the authorities and then
Yes.
and then we do it just?
Well, I wasn't intending to take you to H&N because I think
No,
what's in
thank you.
H&N echoes what is in the other decisions. And the decision of Mr. Justice Baker, which we were going to take you to, relates to ground 2. So I won't take you to that. I hear what you say about ground 2. So those are the authorities that I wanted to take you to. May I then address the point that my Lord is raising as to if one, for example, was to conclude that this judge was wrong to introduce the definitions and that the definitions led her astray, where does that leave one in terms of the exercise that this judge was carrying out? And in our submission, if one looks at the conclusions, first of all, the factual findings that she makes, and then her paragraph 61, where she sets out the threshold findings, in other words, links those matters back to the threshold, there isn't any, as it were, value added by introducing the definition from the NSPCC. In fact, when this judgment was circulated by the judge to the parties in early August, in our submission, the judgment stood alone. It didn't require clarification and it didn't require an expansion by the judge of her findings. At the beginning of this hearing, at my Lord's invitation, I addressed the question of where the judgment would be left if you excised these points within the judgment about child sexual abuse and her specific finding relating to the NSPCC guidance. And in my submission, the judgment continues to stand alone if one excises those paragraphs and provisions, or those sentences and provisions that we went through, my Lord, in the beginning. Because there is a clear conclusion here that this child has suffered significant emotional harm within the context of Section 31. There is a linking of that to the parenting provided by the appellant, who I represent, but also the first respondent father. And that is clearly arising from the parenting that one might reasonably expect a reasonable parent to provide, and so on with Section 31. So if my Lord's question to us is, what is the consequence of the judge introducing the gloss or introducing the guidance? In our submission, it is to introduce a confusion as to the nature of her own finding, and it does, in my submission, distract from, or obfuscate, to use another word, the focus of this exercise, which is, as my Lord has said, to provide a narrative judgment and to make a decision as to whether the threshold has been crossed.
Well, could we, at some stage, you may want to, just to follow this process, get up Section 31, if you need to, but probably you don't. Section 31(2)(a) provides that the court may only make a care order or supervision order if it's satisfied that the child concerned is suffering or is likely to suffer significant harm due to the failure of parenting, broadly. But staying with the phrase significant harm, one then goes for definitions to subsection 9.
Yes.
Whereby harm means, it's defined, ill treatment, etc. Then ill treatment is not defined, but it's said to include sexual abuse and forms of ill treatment which are not physical. So the governing section for the exercise that was being carried out here goes to some effort to situate a concept of sexual abuse within harm, and harm meaning, in this case, ill treatment. And so the court is required to find ill treatment at a significant level. And ill treatment includes sexual abuse. And so I think you were tacitly accepting in your earlier recent submission that it isn't enough for a judge to make a lot of findings of fact and say, I find the threshold is crossed. Full stop. Because there are various ways, various forms of ill treatment. How do you put it?
Well, my lord, it may be helpful to look at the question that the judge was asked by counsel for the father, because I don't think we would disagree with the way that question was asked. If one looks at page 20 of the appeal bundle, paragraph 14 of Miss Wilson's skeleton, and this sets out the question that the judge was asked, which led the judge to provide the clarification. So does my lords and my lady have that? The clarification sought was, and the court clarified the basis upon which a finding has been made that the child was sexually abused, as opposed to a finding that the child suffered significant sexual harm as a result of exposure to sexually inappropriate material. That, in my submission, sits within those parts of Section 31 that my lord has taken me to a moment ago. But there is a difference between those two things, and it was that led the judge then to explain that it wasn't her conclusion, as it were, that the child had suffered significant sexual harm. It was that the child had suffered sexual abuse, and she relied on the NSPCC guidance.
I appreciate this wasn't your request for clarification.
No.
But obviously we see that the father's representatives were not seeking a finding of significant emotional harm, but were looking at it in terms of significant sexual harm. And so, in a sense, what was in issue there was the use of the word harm and the use of the word abuse. And that was what it came down to at that stage. But you seem to ask us to consider a wider possibility, which is that it wasn't sexual harm at all, but that it was, in fact, emotional harm.
My lord, I think it would have to be both.
Both.
I
Yes,
think it would have to be both. I don't think, in fairness to the mother's position and Miss Wilson's position representing the mother, there was no disagreement with the way that question was phrased by the father's representative.
Because if one considers typical main forms of harm being physical, emotional, sexual, for example, then although we have clear concepts of what those might involve in the sort of situations they might arise, they're not sealed units, because physical harm can clearly cause and likely to cause emotional harm. Sexual harm likely to cause emotional harm, and sexual harm may cause physical harm.
Yes.
And so they're not seal units.
I hope I'm not suggesting they are.
No, exactly. No, I'm considering it with you.
Yes.
Do I understand then that there's an acceptance that this might have been sexual harm but not sexual abuse?
Yes.
That's where we are.
Yes.
Yes. While
may I just please just check with Miss.
I will, exactly. I'm going to do my best. I'm going to channel Sue.
You're going to channel Sue.
Just to clarify, in case there is any confusion, that request came from the father's representative.
Yes.
It wasn't a request from Miss Wilson, who wasn't involved in making that request. But it's not our position to this court that we say we disagree with that description or that distinction.
Right. So, in fact, I mean, again, I don't want to put words in your mouth, and you won't let me, but I don't understand you to be resisting the idea that what happened in this case caused both sexual and emotional harm to the child. If one isolates your client's situation, we're well aware that worse things were happening elsewhere. But
The child engaged in sexualized behaviour. I don't think I could demur from a description of that as being sexual harm.
no, and also emotional,
Yes.
causing
of
emotional
course,
harm.
Yes.
Right, but my lady has identified abuse. Could I just say that we're very much aware that there are cases in which leading counsel appear in front of us where junior counsel have conducted the trial and are still closely involved, so that I don't take Miss Wilson by surprise later on. Once you've finished everything that you wish to say, I will ask Miss Wilson whether she wishes to follow in relation to any matters that she considers might help us.
Well, if the court had, and I don't wish to put Miss Wilson on the spot, but if the court had any queries in relation to the current proceedings, Miss Wilson is representing the appellant in those proceedings, as is my instructing solicitor who sits behind Miss Wilson. And obviously Miss Wilson is well versed in the detail, but I don't seek to put Miss Wilson on the spot. May I just, I hope to draw these points together.
Just before you do that, I wonder if I
yes,
can just ask a point of information, actually. The draft judgment was circulated by the judge on, I think, about the 14th of August or thereabouts. Anyway, it was some time before the finalised version. And we got the request for clarification, which you've identified at paragraph 14. In the draft judgment, am I right in understanding that paragraph 53 existed, but it stopped after the word adult sexual activity?
I think I'd have to clarify.
Could you just check that?
Yes,
because
Well, maybe we could, in fact, if Miss Wilson's got it, she can tell us herself.
I don't know where I picked that up from, but that's what I had.
I had it that was the
understood.
fourth.
I think it's in Miss
Wilson's
Wilson's skeleton argument.
Yep.
So I think in the skeleton argument at paragraph 9,
Yeah.
page 19,
Yes.
you will see page 9, or sorry, paragraph 9
that's right,
summarises the findings, the first 3 findings.
That's it. Look, it's at
and
10.
then
That's where
paragraph 10.
that's where we get the first part
Yes.
of paragraph 53, which takes us down to the words adult sexual activity. And my impression was that was the totality of paragraph 53 at that stage. Then comes the question, then comes the request for clarification, as a consequence of which the judge supplements paragraph 53 with the words that begin the NSPCC definition. Is that right?
That is my understanding. Miss Wilson is
Okay.
just double checking.
Thank you very much.
But what I suppose is relevant to the substance of this appeal is it included that first sentence which triggered the clarification.
It did. And the first sentence, of course, includes the phrase sexual
Yes.
abuse. So that was there at the outs before the request for clarification came in. It was, yeah.
So, my lords and my lady, just to draw these matters to these threads together, it is our submission to the court that if a definition is to be applied, it should be the statutory definition, that having been arrived at by the wide consultation process. But we do say that if a definition is introduced which causes misinterpretation or is open to multiple interpretations or it introduces ambiguity, then it isn't helpful and it doesn't assist either in relation to fact-finding or in relation to threshold, but also the next part of a process which does arise for this appellant at present, that being welfare investigation and the assessment in relation to risk profile. One issue, for example, which arises at the moment is that there is a question mark about assessment of the mother, potentially in a residential assessment, and a finding of sexual abuse requires significant explanation and is potentially problematic in terms of her being suitable for assessment in such a facility. And that's a matter which was conveyed to me this morning. I don't intend to address you on ground 2 because I hear what the court has said, except simply to point out, of course, that had these matters been raised by the judge, and we don't make criticism of the judge, this was a difficult judgment, it took a long time to prepare in very difficult circumstances, but had they been raised, they could have been addressed by counsel, and one only has to look at the very thorough, very careful, very detailed skeleton of Miss Wilson to see how the court may have benefited from having those exchanges with counsel. And there is a degree of procedural unfairness, I suppose is the best way to characterise it, if a court is going to make that sort of finding, relying on guidance on which she has not been addressed by counsel. It would have, if nothing else, assisted.
We've arrived at a position, haven't we, where the judge found that there had been sexual abuse. There was then a query, and then she confirmed the finding, but by reference to that particular piece of guidance.
Well, I suppose the difficulty with it not having been raised by the judge in submissions with counsel is whether the judge was using that or using the working together in her first draft of the judgment, as it were, because she offers that as the explanation and relies on the fact that on her reading of the guidance, the NSPCC guidance, it's on all fours with the working together guidance. And in our submission, it's not.
Could I just take you to one more reference, which is at page 67
Yes.
of the main bundle?
Of the appeal bundle?
Yes.
Yes.
Which is the schedule of findings.
Yes.
A not untypical attempt to get the evidence into some sort of focus. But I'm looking at the left-hand column and the bold headings.
Yes.
And there are 3 or 4 of these. But take the second one, for example, which is what we're mainly concerned with.
Yes.
Here, it is findings in relation to sexual abuse in 2022. So the local authority has come along and has made this allegation, which it then particularises at considerable length, going on for 10 paragraphs or more, as to different sorts of problems of the kind that some were upheld and others were not upheld. Some don't concern your client at all. But I'm still hovering over the fact that when a local authority comes along and said there has been sexual abuse in this case, it seems that the judge ought to be reaching a conclusion about that, not simply ducking it and saying, I've made findings. The threshold is crossed.
I don't think we're suggesting that. Our understanding, and Miss Wilson flags this in the skeleton argument, is that the local authority's findings of sexual abuse were primarily directed to contact sexual abuse. It was part of their case in the court below, as my lord said earlier, that there had been some sort of contact sexual abuse. So, although, as one often sees, and this is the reality, various pleadings are pleaded together. When we looked at the judgment earlier, my lord may recall that I took my lord to that paragraph of the judgment where the judge recorded the local authority was seeking a finding for contact sexual abuse in relation to the father, and that arose from bruising and so on. That finding was not made by the judge.
Yes.
There wasn't anything further I wish to address you on, unless you wish me to deal with anything else.
No, thank you very much, Ms. Bartrell. Yes, Ms. Wilson.
My Lord, in terms of paragraph 53, which you asked about, I can confirm that that is reproduced in its entirety from the draft judgment as per my paragraph 10 of the skeleton argument. Is there anything else that I can assist you with in terms of the...
I don't think so, but thank you very much.
Thank you.
Thank you both. Right. Yes. Ms. Webber.
My Lord, I'm not sure how helpful I'm going to be, but you have a clear and I hope concise skeleton argument from the local authority.
Yes, that was Miss Troy's document.
It was, yes, and of course Miss Troy was the trial.
Is it the one that we've got at?
There are one at 114 to 118.
Sorry, start again.
Bundle. There is a skeleton at 114 to 118 of the core bundle, and then a supplementary skeleton argument at 121 to 128 of
right,
the
just a moment. 114.
Yes, that's the main one, my Lord. The supplemental really dealt with the point that you had raised about the online sexual
right.
act and relevance.
Now, I've obviously read the original document at the time of granting permission, but it doesn't actually have a link in the electronic version, and so I've read the second one, but not recently
Then
the first.
the second one reproduces in its entirety the first
Very well.
skeleton argument, and the only addition in the second skeleton argument is just to deal with the point that my Lord had raised in the permission to appeal, which was any relevance of the Online Safety Act, and Ms Troy went through that act and didn't see that it was relevant for these purposes, and perhaps it would be prudent to remind ourselves, and you've already made reference to it, that what Her Honour Judge Earley was conducting was a composite hearing. She was looking at the fact find, the threshold, and then the welfare. And what the local authority says is what is clear from the paragraph 61 is where she brings all her findings together and then sets out how each of them link to what she needs to do and the exercise she needs to conduct, which is how then it relates to the section 31 threshold and the harm that emanates from those findings, because she not simply refers to the sexual abuse and the emotional harm, but she talks about the risk of physical harm from the findings that she has made in respect of each of the parents. What the local authority says is that the judge was entitled and has not erred in then ascribing the findings she made in respect of the sexual behaviours of the child and the exposure to the sexualised material, ascribing that to being harmful and that to be in sexual abuse. My Lord has already made the point when one looks at section 31, the court must be satisfied of the harm. The harm is defined as ill treatment, and ill treatment is further defined as including sexual abuse. The Working Together group was a resource that I understand was provided by the parties, agreed as providing a definition of sexual abuse in accordance with P. And what the local authority says is what is distinguished within that document and that definition is the wording that is used when looking at non-contact abuse, and it refers to involving children. It doesn't refer to enticing or forcing or encouraging, as it does when it then goes on to give examples and definitions of other forms of non-contact abuse, and we say that is distinct, and that involving a child does not require a positive action, an enticement or an encouragement, but can equally arise as a result of omission, as a result of negligence, which is exactly what the judge found in this case, that there had been negligence on behalf of the appellant, because she found that on occasion, for whatever reason, devices were given to the child on which the mother was aware that there was likely to be sexualised material. And so the local authority's position is that she was correct in identifying that behaviour as being that of non-contact sexual abuse. The local authority goes on to say, when one looks at, and if that is the interpretation accepted by the court, that involving can equally mean omission or negligence, as of course this is what this judge found, then query, is there any distinction between that and then the examples and definition given by the NSPCC? And again, we say that it is of note that when the NSPCC gives the examples of non-contact sexual abuse, the not taking measures to protect, as it were, the child from the sexual material is one of the only examples it gives where there doesn't require a positive action. It doesn't say enticing or encouraging. It says didn't take measures. We say that fits with the interpretation of the working group definition of involving a child in looking at or watching sexual activities. So local authority puts it perhaps in those quite simplistic terms. The local authority agrees with comments that have already been made about if one looks at both of those definitions through the prism of the opening line, then it doesn't go on to make sense what then follows. One would assume that if it was meant to be a positive act when it came to sexualised material, then that's exactly what would have been said, as it said on the other examples that are given. So that's why we say the judge did not fall into error, and her judgment stands as it is. That component was a significant component in this case. The impact one can see from the judgment of the exposure to that material went beyond emotional harm, and the judge actually says, and it's at paragraph 41 of her judgment, 045, she says that I find that both parents have exposed the child to sexually inappropriate material, and this has led to confusion in her young and impressionable mind as to what was appropriate for herself. So she goes beyond just the emotional harm, and that it is having...
I think that where we've got to with your submission as Ms. Fottrell's submission is that there's nothing between you on that, because in reply to my lady, Ms. Fottrell
Yes.
was happy to accept that there had been both emotional and sexual harm.
Yes.
it was a matter of the label, and what she objected to
Yes.
was it being described as sexual abuse. So I think you're on firm ground there
I'm
so far as
with-
the parties
well,
are concerned.
well, then the local authority's position, as I say, is clear and quite concise, that actually the behaviour that was found by the judge fits the...
Right, so your submission is basically in 2 words, that's abuse.
Yes. Yes.
Now, this is not determinative at all, but it's just, we're obviously aware of the human situation here. Are you instructed to any degree in what is happening in the case of the next charge?
I'll just confirm. Me personally,
No, but just do you have information about it?
Only the information that Ms. Fotter has shared with the court as to the current circumstances for that new child.
Well, I was just thinking, as in a sense, as a sort of impermissible acid test of this. If some interest to know what the threshold that's pleaded in relation to the baby
Yes,
is.
it's not the local authority that sits behind me.
No.
Are the applicants in that case? So I'm afraid.
Well, we won't take time on it. It was simply if it was readily known to everybody, then.
No, it may be more actually known to Ms. Wilson, as she is, I understand, involved in it, but not to us. So, my lord, there is the local authority's case. Quite simple.
Anything else? No. Well, that's very, very helpful. Thank you very much indeed, Miss Webber. Any reply?
No, save that Ms Wilson is just checking in relation to threshold in the current proceedings, and it may be that my lords, my lady will wish to see that. That can be sent through. It's a different local authority.
If it's easily done, then if you send it to my clerk.
Yes.
I do stress that it's not this is contextual.
No, of course.
But whatever else we decide, we certainly take your point that words matter. But the impact of words, if they were taken out of context and read by somebody who had not got the time or depth of interest that we've had to have in the full reasoning, has to be considered. All right. Well,
Anything else? No, thank you.
no. Good. Well, thank you very much indeed. There's, it says we have agreed a narrow point, but it's interesting and important. We will take time to think about it and let you have our judgments in due course. Please help us by finding the mistakes and letting us have a draft order reflecting our decision. And we won't need to trouble you to come back for the hand down, which will be done electronically. Thank you very much indeed.
All right.